But yes, this is our first virtual town hall for renters. And my name is Erin Lee. I'm one of the social work care coordinators with the City of Annapolis Office of Community Services. And I'm here with our other social work care coordinator, Shania Rowling, and our supervisor, Aisha Young, with the Office of Community Services. And we're just so happy tonight to help in hosting the community legal services, to take some questions, get some answers tonight, and also share information about legal services in the area, as well as rental questions as well. So we'll go ahead and get started. And so for tonight, we just have our ground rules, our introductions. We also we'll have our community legal services representatives do a presentation. And we'll also have a section for any questions for our community legal services representatives about renters' rights. And finally, we'll be giving out our contact information. And next, just a few ground rules. We just ask for everyone to please stay muted during the presentation. And then when it's time for our question and answer period, you're definitely more than welcome to come off of mute. We ask also that there's no yelling, insulting, or threatening anyone here in the meeting tonight. Just hold all questions until after the presentation. And you're definitely more than welcome to put any questions that you might have in chat during the presentation. We just ask that you do not put any confidential or identifying information in chat, or no specific individual issues. We just want to make sure everyone's privacy is respected. So tonight we have Ms. Anna Goldfaden, who is the Community Engagement Coordinator, and she connects community legal services clients with support services and financial resources. She also provides individual support to clients with special needs and circumstances. We also have Kathleen Hughes and Amy Siegel. They're the supervising attorneys for the Anne Arundel County Eviction Prevention Legal Program. So between the both of them, they have over 50 years combined legal experience representing tenants in Annapolis and Anne Arundel County. They also oversee a team of 9 attorneys in Annapolis and Glen Burnie District Courts. And we also have Jonathan Asperia, who is the paralegal for the Eviction Prevention Program. And so I'll go ahead and hand it off to our community legal services representatives that we have here. And yes, we're so excited to have them. And once again, if you'd like to put any questions in chat, feel free. And there'll also be a section for after the presentation as well for more questions.
Hi, everyone. I'm Kathleen Hughes, and I'm very excited to be here, and we're pretty excited about this first town hall meeting. I'm going to give you the quick introduction to Community Legal Services, just tell you kind of who we are and what we do here in Anne Arundel County. We're a nonprofit legal services organization, which means our services are free. We were founded in 1985 in Prince George's County, and we used to be called the Law Foundation. That might ring a bell with some folks who have been in the area for a long time. We do provide free legal services to income-eligible Marylanders. We are a designated access to counsel and evictions provider, and that's shorthand for is ACE. And what that means is that, Maryland established, or the legislature established a law in Maryland that provides for tenants who are at risk of eviction or homelessness to have access to legal counsel before they're evicted. And so as part of that statute, because folks are entitled to have attorneys, we are at the courthouse every day, 5 days a week, in both in both Glen Burnie and Annapolis courthouses. We represent folks in judicial proceedings at the courthouses, and we also represent folks in administrative proceedings when their housing subsidies are being terminated. We do represent people in Prince George's, Anne Arundel, and Montgomery counties, but the team that you see here tonight is the Anne Arundel County team. What we do in Anne Arundel County is, as I said, we maintain a daily in-court presence for failure to pay rent dockets, and we are there 5 days a week in both district courthouses. If you come to the court. The dockets, the rent dockets are at 8:45 every day, every morning. And we do have folks that sometimes will pop into the courthouse. Sometimes we're too busy to deal with it. But even if you don't have a hearing that day, because we always have attorneys there. We also handle breach of lease and tenant holding over cases. And as I said, we do administrative termination of subsidy cases as our resources allow. So we look forward to serving you, and that's what we do. Next slide, please.
Good evening, everyone. My name is Jonathan Espria, and I am one of the paralegals for our eviction prevention team. Um, the types of assistance that we offer to our clients is going to be brief advice as well as counseling, and we may also refer someone out to other organizations depending on what they would need. For instance, whether that be financial assistance, and we also represent individuals in court and other administrative proceedings. If you'd like to apply for one of our services, you're welcome to call our number at 240-391-6370, extension number 5, and that's going to be our direct client line. And you can reach us by phone Monday through Friday from 8 a.m. to 6 p.m. And on the screen, we also have the MD relay number, and that's just a number that's offered to our members in the community who are either deaf or hard of hearing. If you'd like to go online and apply for our services, you're welcome to do that as well. You can do that at www.clspgc.org and select the Apply for Services tab. Once you choose that tab, you can choose the online form for whatever legal service that you need. Specifically in this context, that's going to be landlord-tenant. And you can just fill out that intake form anytime. So you could even do it after hours. It'll just be reviewed by one of our staff the following business day. If you want to forego that option, you can also email us directly at info@clspgc.org. You can just leave contact information and just a brief snippet of your circumstances and what kind of assistance you're seeking. Next slide, please. You're also welcome to call 211. That's an information line set up by the state of Maryland that can pair people up that are seeking legal assistance with an appropriate organization. If you have a failure to pay rent case that you're in and you'd like to call through that number, you're welcome to do that. But just know that there may be a chance that you could be paired up with a different organization. So if you're going to call, we would ask that you make it easy for yourself and just call us directly. If you find yourself in a situation where you're in a failure to pay rent case and you don't feel like you have enough time to call us, please feel free to come to either the Annapolis or Glen Burnie District Court. We have attorneys there every single day, and we do offer same-day service. The way that works is we just ask that you show up to the courthouse as early as possible. Most days that's going to be 8:30 in the morning, and you'll just be screened by our staff to see if you're eligible for our services, and you would just complete an intake application on site. Once that application is done, you'll be paired up with one of our attorneys who will go ahead and represent you in court that day. The only thing that we ask that if you do go this route, we just ask that you bring any relevant documentation with you, whether that be notices, receipts for any payments that you've made, and the complaint that was filed for the case. It just saves us time and allows us to move forward on representation without having to pull documents that same day. And I will go ahead and pass this off to one of my colleagues.
Actually, Jonathan, that's your slide. You could do that too if you don't mind.
Oh, no problem at all.
Yep.
So for failure to pay rent hearings, the application is reviewed by staff, and we tend to return any calls left and any voicemails left to us within 24 hours. For same day help in court, we typically screen people on site as well, and they're typically represented in court on the same day by an attorney. In terms of for people who don't have a case that's filed in court and are just seeking either counseling or brief advice, you're welcome to call us. We would just send a document that same day with what's called a consultation agreement. It just gives us permission to give legal advice on whatever matter that you're experiencing, and it clears us of any liability. Once that's done, community legal service staff will contact the tenant to discuss the case and provide any relevant advice. And even if you aren't able to sign our consultation agreement, I know some people have difficulty with technology or computers. We can still assist you. We'll just work around the difficulty and just try to get your consent a different way. For any other kind of housing case, whether that be breach of lease or tenant holding over, you're still welcome to submit an application for our services. Those cases tend to be a little bit more complex and require more time in order to review the facts. But once that's approved, you'll be able to receive legal advice the same way, whether that be, compared to a failure to pay rent case as well.
Okay, good evening, everyone. My name is Anna Goldfadden. I am the Community Engagement Coordinator with CLS in Anne Arundel County. And I wanted to briefly talk about the County Rental Assistance Program that is with Arundel Community Development Services, also known as ACDS. We work very closely with this program to assist clients who may find themselves in need of financial assistance. Nobody at CLS has a direct affiliation with ACDS, but we do work very closely with them. So I just wanted to talk about some of the requirements that they have for providing assistance. So at this time, applicants must have an active warrant of restitution or an eviction notice in order to apply with the program. Assistance is limited to $5,000 or the amount listed on the warrant of restitution. That'll be whichever is lower. And at this time, ACDS is requiring documentation of a financial hardship, such as a termination notice, medical report, something like that. And applicants must not have received assistance within the last 15 months. So I have here the instructions to apply, which is to send an email to evictionprevention@acdsinc.org with your contact information and a copy of the warrant of restitution or the eviction notice. And I just have a little note here that says, see the website below for all the other information. There's a lot of great info on their website. So the link is right there so you can see the full list of requirements and further information.
I just want to interject really quickly that Anna does a great job connecting our clients, and so our program is unique in that way that Anna has some direct connections, and she also is a great resource for other community resources that offer rental assistance and other things like food and BG&E bills and things like that. So thanks, and I think we can move on.
Alrighty, and before we get started with some of the questions, I just wanted to let everyone know that for the slides, we will also be emailing these to participants. We'll have some information at the end just to let you know how you'll be able to get the slides just in case. But, from we recently, also Community Services recently released a survey to Annapolitans, and we had about 33 different responses. And these were kind of like the most popular responses that we had from the survey. And so we just wanted to go over these questions with everyone tonight. Of course, once again, feel free to put any questions you might have in chat or ask, during the question and answer period. But we were just going to review over these questions and have our representatives from Community Legal Services give an answer and give us a lot of good information. So first question starts off as, what are my rights as a tenant? In Annapolis, what can you be looking for? All righty, so I'll go ahead and let our representatives answer.
Good evening, everyone. My name is Amy Siegel. I'm really happy to be here tonight. What are my rights as a tenant is a pretty thick subject. So what I'm going to do is go through some of the highlights to give you some information about general tenants' rights, and we're going to cover some information about evictions and court process. So what are my rights as a tenant, and where do those rights come from? So tenants' rights they come from statutory law, essentially, for the most part. So that can be Maryland law, it may be Annapolis code, or it may be the Anne Arundel County code. The Maryland Office of Tenant and Landlord Affairs published something called the Maryland Tenants Bill of Rights. That Bill of Rights is linked here for your review. And it is essentially a summary of the laws in Maryland that define tenants' rights on many topics. What I'm going to cover now is highlights of some of the things that you find in the Tenants' Bill of Rights, as well as some additional information that may be particular to Anne Arundel County and to the city of Annapolis. And I'm just going to whip through this because there's a lot of information. Such as rental application fees. Everybody's applying for apartments and places to live. There is a cap of $25 for landlords who rent more than 5 units in Maryland, unless the actual cost is more. So there are caps on application fees out there to protect tenants. When is a written lease required? Well, if a Maryland landlord rents 5 or more units, they will have to use a written lease. But in the city of Annapolis, a written lease is required, even if the landlord does not rent more than 5 units. The initial term in the city of Annapolis offered to a tenant must be 1 year. That is not the case throughout the state of Maryland, but it is in the city of Annapolis. Security deposits. Beginning October 2024, there is a cap on security deposits of 1 month's rent for leases that began after October 2024. Rent receipts. In Anne Arundel County, landlords must give a receipt for cash payments, or if the tenant requests a receipt. So if a landlord is telling you, well, you have your receipts from your money order, you don't need a receipt. If you ask for a receipt, they are required to give you one, and we do recommend trying to get one every time. The Tenant Bill of Rights covers conditions of rental units, which must be safe and habitable. Kathleen Hughes is going to talk a little bit more about that in her presentation. All landlords within the Annapolis city limits must have a rental license. That is different from the county rules, which limit licensing requirements to other factors. But in the city of Annapolis, whether it's a single-family home or an apartment, every landlord must have an operating rental license. So what happens when a written lease expires? Well, if you're in a HUD-subsidized property, most of these leases must be annually renewed, even if the date of the lease comes to an end. There is restriction on how landlords can terminate leases for folks in subsidized housing. So those normally renew annually unless there's some kind of a termination for a specific reason, and there's a court process for that. For non-subsidized landlords, a landlord's got to give 60 days notice if you have a month-to-month lease. And if you are in a 1-year lease and it's coming to an end, a landlord must give 90 days notice in order to choose not to renew your lease. For security deposits, the law in Maryland says that landlords must refund security deposits within 45 days of a tenant vacating a unit. Or if they're not going to refund all or part of it, they must send an itemized list to the tenant, which details the amounts withheld and the reasons for it. There is a legal process for tenants to follow if they believe that their security deposits were wrongfully withheld. Next slide, please. Continuing on with rights as a tenant, we're going to talk about the court process. This is specifically for failure to pay rent. In Maryland, the law for everyone says that landlords must give a 10-day written notice to a tenant before they file a failure to pay rent action. The notice is to put the tenant on notice of the landlord's intent to file if the specific amount of rent that is claimed to be late has not been paid. For HUD public housing and project-based rental assistance, currently the regulations require a 30-day notice before a landlord may file a failure to pay rent action against a tenant. And that 30-day notice has to have quite a substantial list of information in that notice. And that is something that you can speak to an attorney about if you have some questions. We do want to caution you that there is possibly change on the horizon with the new administration in the federal government. HUD has repealed the 30-day notice and has notified the public that they plan to change that to a 14-day notice as of March 30th, 2026. So in just a few days. Now there may be a court challenge to that, in which case we'll try to get the word out that a judge has put that on hold, but at this time, that's what we can expect to happen. Landlords may file a court complaint after the 10-day notice expires. The procedure is that the sheriff is responsible for posting a copy of the complaint on the tenant's door and mail it to the tenant. Failure to pay rent hearings occur very quickly in Anne Arundel County. State law requires that the court schedule a failure to pay rent hearing, the initial hearing, within 5 business days after filing. So realistically, what that means is that you will have a court hearing exactly 1 week after the landlord files his or her complaint for failure to pay rent. There is currently no minimum advance notice required for a tenant to be notified of the hearing, and that does pose problems for many people, especially in our county, because some counties, sheriff's office don't follow, or the courts don't follow that law strictly, but Anne Arundel County does. So what we see is many tenants getting only 1 to 2 days advance notice, meaning that the court complaint will show up on their door posted by the sheriff, maybe just a day ahead, sometimes even later than that. We would recommend that you talk to an attorney if for some reason you find out that a hearing happened without you ever having notice. That does happen occasionally, and that's something that we can help with. So the step after the tenant is notified is that a hearing takes place before a judge. The result may be a judgment of possession, repossession for the landlord after a certain period of time. It could be a dismissal of that case if the facts warrant, or it could be a postponement of that case to a different day. Next slide. So let's talk about evictions generally, not just failure to pay rent evictions. Landlords must use court process. No self-help evictions are permitted in the state of Maryland, and that can look like changing the locks, shutting off utilities, or some other type of necessary or essential service that normally would be provided by the landlord, or denying you access to the inside of your unit. Anything that denies you your right to be in possession without the court process being used is not permitted in Maryland. Landlords must receive first a judgment of possession from a court before taking any steps to evict a tenant. There are different types of court cases that a landlord may file to request an eviction of a tenant, not just failure to pay rent, but some of you may be familiar with other types of possessory actions where the landlord is trying to repossess the unit, such as a tenant holding over case where the tenancy has expired and the landlord is trying to repossess the unit, or such as a breach of lease if the landlord is claiming that the tenant has violated some essential requirement of the lease and it justifies eviction. The step after court, if the landlord prevails in their case, is a warrant of restitution. That is sometimes we call it the eviction ticket. It is a document that the landlord files with the court, asking the court to sign off on the eviction because the court has entered judgment and the tenant has not either paid the rent or there's no defenses and the period of time for appeal has passed. In rent cases, a tenant has the right to redeem or pay and stay. There are limits to this. The tenant only may do this 3 times in any 12-month period to have the right to pay and stay. After the third judgment, a landlord may exercise his or her right to ask the court to foreclose or take away the tenant's right to pay the rent and to stay. I do want to add that once a warrant of restitution has been issued, there may be additional fees that are added to the rent that the judge decided the tenant has failed to pay that would be necessary to pay in order for the tenant to redeem. Finally, there's a 6-day written notice that is required from the landlord to the tenant of the scheduled eviction date. This is a fairly new law. It requires that a landlord send a written notice to the tenant or provide a written notice to the tenant that gives a minimum of 6 days notice and the exact date of the eviction. Next slide, please. Eviction changes ahead. This is really important and it's brand new. So as I said a minute ago, the current state of the law in Anne Arundel County, which holds for the city of Annapolis as well, is that tenants have a 6-day advance notice of eviction. And then procedurally what happens if an eviction takes place and the tenant does not redeem by paying the rent or is not entitled to redeem, what happens is the sheriffs oversee an eviction and they allow the locks to be changed after the landlord removes all the personal belongings of the tenant and puts them outside the unit on the public right of way. This is probably something people have seen. It is really unfortunate, but the tenant does have the right to retrieve their property because it is outside the unit, although it is at risk of being stolen or lost when that process happens, which can be very problematic. However, there is new Anne Arundel County eviction law on the horizon. It is here and it will happen effective July 1st, 2026. The notice has increased to 14 days. So a tenant will have a 14-day written advance notice of an eviction date. However, once the locks are changed, personal belongings that are left inside the unit no longer belong to the tenant. The tenant is immediately dispossessed of the right to their belongings if they are left inside. Personal belongings cannot be retrieved by the tenant, and there have been no exceptions written into the law, even for things like medication, phones, cash, birth certificates, anything, sentimental items, anything valuable. It immediately, under this new law, will become the property of the landlord. There is a 24-hour hold written into the law, but it is not in order for the tenant to come back and retrieve their belongings. It really was put in there to prevent the wrong address from being locked up. There's a 24-hour hold period to ensure that mistakes don't occur and the wrong unit is locked up. So finally, landlords can sell, donate, or trash the belongings after 24 hours after the locks have been changed. At this point, there is no mechanism for a tenant to retrieve or get those belongings back. Perhaps tenants can find out if or where property is being sold. We are fearing that landlords may try to sell those belongings back to the tenant. So this is a real unfortunate development in the law, but it's coming July 1st, 2026. We are not aware that the city of Annapolis, as a municipality, has taken any steps on its own to ameliorate this Anne Arundel County ordinance. So that is not something that we are aware of. Next slide, please. How do I request the grievance process? Next slide. So what is the grievance process? What is a grievance process? Well, it is the right of a HUD subsidized tenant to meet with housing authority officials or an owner, if you're in a different type of subsidized housing, to resolve a situation or a problem that adversely or negatively affects an individual's rights as a tenant. This is a non-court process, and it's intended by HUD to allow tenants and landlords to try to resolve issues so that they don't end up in court. There are different processes in place depending on what kind of subsidized housing you reside in. If you're in public housing, the grievance process is contained in something called the ACOP, which stands for Admissions and Continued Occupancy Policies. It basically is the housing authorities' policies and procedures for many of their, for operating their properties. And it is also written into the federal regulations. The two-step process for tenants who live in public housing is this. The first is an informal settlement meeting when a tenant asks for the grievance process. Even if you say grievance hearing, if it's the first step, what you will have is an informal settlement meeting with a housing authority official. And the housing authority of the city of Annapolis's policies and grievance policy states that within 24 hours of having this meeting, they are supposed to issue a written summary that details the issue and any resolution or settlement offered to the tenant. The notice should also state that if the tenant disagrees or is dissatisfied with how the housing authority has offered to resolve the problem that the tenant has raised, they may ask for a formal grievance hearing, which is more formally held. It may be in the form of a meeting with a hearing officer. It could be with a panel of volunteers who listen to the problem and make a decision. But the formal grievance hearing request for HACA, I believe, is within 10 days of receiving the summary. But all of the rules are going to be found in the written policies. For folks in project-based subsidized housing, which is not public housing, the rules that govern those programs require that termination letters from the landlord must give the tenant 10 days with which to discuss the termination or other disagreement that has risen and caused the landlord to issue the notice with the management before taking further steps. So it must inform the tenant of their right to notify and meet with them within 10 days. And that is an opportunity to try to resolve the difference or the issue. And finally, tenants with vouchers. When the housing authority, which oversees the voucher, issues some kind of a notice, makes a decision that is adverse to the participant, like they decide that you have violated a program rule or they're changing your rent calculation, the tenant has a right to an informal hearing. It's a one-step process, an informal hearing. Generally, this may be, again, with a hearing officer that is brought in by the housing authority, an outsider generally, or with a panel of decision makers, sometimes members of the community. Next slide, please. How do I request a grievance process? Well, for HACA public housing, the informal settlement meeting, a verbal or a written request to a property manager or a HACA official. If you have received a notice telling you that you've violated a rule or that they're taking an action that you disagree with, then you must request the meeting within 10 days of having been notified of the adverse action that the housing authority is taking, such as, again, a notice of intent to file failure to pay rent, a termination of tenancy, and this informal settlement of grievance meeting is the first step. We always recommend that you do so in writing, even if it is in the form of an email, because as you probably know, something in writing creates a paper trail, so you will have proof that you made your request and that you made it on time. The informal settlement of grievance notices, the decisions will tell a tenant that if they were dissatisfied, they may request a hearing within 10 days. And again, it should be done in writing. HACA has a form, which we've linked to at the bottom of this slide. It's a grievance request form that you can use to request a grievance. But you don't have to use the form as long as it's done in writing. For project-based subsidized housing, a written request for a meeting within 10 days of receiving a notice of rent increase or termination is how you request a grievance. And for tenants with vouchers, again, you need to make a written request for an informal hearing within 10 days of receiving the notice of termination or the notice of some kind of adverse action like a rent increase that you disagree with. Next slide. Okay, and I think I'm done.
So I think the next, one of the next questions or one of the next main questions that came up in the survey was, what can I do if the landlord or property manager has not been responsive to my request for repair or extermination or anything else? Next slide, please. So I'm going to talk a little bit about this. This is a huge issue. You know, a lot of the, certainly a lot of the subsidized housing, but a lot of the private housing as well in Anne Arundel County is um, not really a desirable place to live, and there are a lot of issues and a lot of problems. So there's kind of two ways to attack this legally in Maryland. And those two ways are by using the rent escrow statute or the Tenant Safety Act of 2024, a new statute that's been enacted that has kind of broadened the rent escrow statute. The rent escrow statute's been around for a really long time. It's supposed to be a way to provide tenants to get repairs, but the conditions for a rent escrow case must be serious and dangerous. And that means like, you don't have any heat in the winter, you don't have running water, there's mold so bad that, and a lot of places do have this, but they're life-threatening conditions. So, what happens in a rent escrow case is that the tenant asks the local district court to set up an escrow account, and an escrow account is just an account where you're paying your money to the court. You're paying your rent money directly to the court rather than paying it to your landlord. And then the court holds on to that money until they hear your case. And it's an affirmative case. So you're filing it, you're saying the landlord is not doing what they're supposed to do. I want to put my money in escrow until the landlord makes these repairs. So the court hangs on to it until your case comes to court and the judge hears the evidence and makes a decision. Oftentimes with these cases, these and the Tenant Safety Act, which I'll talk about in a minute, these cases our judges are rarely give a full abatement of rent. They think that there is a value in at least having a roof over your head. So if you're doing rent escrow, I would say to you, unless your conditions are really uninhabitable, unlivable, you shouldn't be living there anyway, and it should be condemned. the the landlord's going to get some of that rent money back, but maybe not all of it. But that's kind of how the rent escrow works. You're putting your money into the account, you're going to give the judge the evidence, and then the judge is going to let you know after hearing the evidence how much you get and how much the landlord gets. The Tenant Safety Act of 2024 works kind of, they do sort of work together, but this set is the basic premise is that every rental property that is offered for lease is deemed to be fit for human habitation. And so your relief the available relief is similar to rent escrow in that you get a maybe discount on your rent. There's other relief too. You could terminate your lease early. You can maybe have the court order certain interventions. But with this particular remedy, unlike rent escrow, if you're seeking relief under this law, you don't have to pay rent into an escrow account. You can withhold your rent. And if you're withholding your rent, and we'll talk about this a little bit more in a minute, but we don't necessarily, it really is a last resort because you don't want to dig yourself a hole by withholding your rent. If you're going to withhold your rent, maybe you want to withhold part of your rent because the chances of the judge giving you all of that rent, giving you credit for all of that rent are pretty slim. So this is a defensive act. So if you withhold the rent, what's going to happen? The landlord's going to file a failure to pay rent case against you. And then when you go in for your failure to pay rent case, you raise this as a defense and say, well, Your Honor, I asked for repairs. The landlord didn't make those repairs. And so I withheld my rent and that's why I didn't pay. So I want you, Judge, to order that I don't have to pay that rent or that I only have to pay part of that rent. Okay. So I sourced this because the People's Law Library of Maryland, and there's a card at the back that tells you how to get there. But People's Law Library of Maryland is really, really good, and they keep up. They keep things pretty current, although they don't have some new information on there that we'll get to in a minute. So next slide, please. Okay, so when you're thinking about either rent escrow or warranty of habitability case, a conditions case, you want to be sure that you're keeping track of every communication with the property. And this is where people really do fall down because you call, and it's frustrating. You call the property, you call and you say, I have this repair that needs to be made, and you don't get any response. Or, they say, oh, I never got your request, or they're just non-responsive. So you really want to keep a record of this. And I just recommend that you have a little calendar next to you or something that, some kind of a way that you can just track who you talk to, when you talk to, or how you made that communication. Can you go back for a minute, Aaron? Can you? Yeah, there we go. So the method of contact and your specific request, because when you go for your rent escrow case or your warranty of habitability case, the fundamental thing that you have to show is that you gave notice and you allowed time for the landlord to make those repairs. And if the landlord didn't make the repairs after you having given notice, then the judge is going to be listening to you. But if you don't have any record of having done that, and sometimes when you put things on the portal, you're not going to have that record. So keep a screenshot. But you really need to keep good records. And I hate to put that on the tenant, but that's kind of where we are. So once you've given them a call and told them what the problem is, you have to give them time for repair. And if it's a routine maintenance request, what the ACOP says, whoops, gotta go back. What the admissions and continued occupancy policy that Amy was talking about says is that for HACA, 30 to 60 days is a routine. They're allowed 30 to 60 days for a routine maintenance request. 30 days is the standard. So if it's a routine, if you're having an issue and you make a report and nothing happens in 30 days, then, you can make your report again or you can take the next step. So that's for routine. It's supposed to be 24 hours if it's an emergency or life-threatening issue. So if you have a leak or a pipe burst or it's 0 degrees outside, you don't have any heat. So they're supposed to do that within 24 hours. If they don't respond to that, there's a couple of, then you can file your rent escrow case, or you can wait, you can withhold rent and wait for them to sue you. But we recommend immediately making a complaint to the appropriate authority, which would be the city of Annapolis for, for the city. And if you're outside the city of Annapolis, it's the health department that handles that. And I've linked to the health department's website. They have an online complaint form. I don't see an online complaint form for the city of Annapolis, but that is the general number for their licensing to make a complaint. So, okay, next slide, please. So I wanted to put one slide up just for mold because we have so many serious mold issues, and this is a new statute effective July 1st of last year that specifically deals with mold. So if you have mold in your unit, there is this new statute, Real Property 8220, that says what a landlord's responsibilities are. I first cited to the Maryland Environmental Code, which provides the relevant definitions of what it means for dampness, mold, and what mold remediation means. So those definitions can be found there. But the real property statute says that a landlord, when you rent a unit, now has to provide a pamphlet that talks about mold. And they have to provide you with a copy of that pamphlet. They have to also provide you with a copy of it if you request a pamphlet. Like if you didn't get one which you probably didn't because you haven't leased up anytime soon. So if you request one, they have to give you a copy of that pamphlet. If you have mold issues, and you notify them, the landlord must perform a mold assessment within 15 days after receipt of written notice regarding the detection of mold from, it looks like I dropped off the slide there, but from you, the tenant, a tenant or building occupant. There's a sample letter next slide in a minute. We don't have to go there yet, Erin. But if the assessment detects mold, then the landlord shall, and it says shall in the statute, which means they must do this. They have to perform mold remediation within 45 days after the assessment is completed. Or there's a little wiggle room for them within a reasonable time after the assessment is complete if it's not feasible for them to do the mold remediation in 45 days, which sometimes if the mold is so bad that they have to start tearing out walls, that may come under that exception. The landlord must also ensure that the mold assessment follows all the recommended industry guidelines. Like they can't just bring in any old person to wash down the walls and throw bleach on it. And then they also, during that remediation, must communicate with the tenant to provide you with updates and relevant information while the remediation is going on. Okay, now next slide, please. We have provided in this next slide, this is a sample letter, mold letter that you can use to provide notice to your landlord if you have mold. So once you've provided the written notice, and it has some information in here about the statute, but once you've provided that written notice, they have 15 days to get the assessment done, to get the mold assessment done. So that's a really good tool. I don't think a lot of people have used it yet. It is brand new and, hasn't been tried in the courts yet, but, use that tool. So, okay, next slide, please. We're trying to whip through this so you guys can get all your questions answered too. So this is an easy one. The next questions were, can I negotiate my rent with a landlord or property manager? And how do I talk to my landlord property manager about delaying or stopping rent increases? Next slide, please. The short answer to can I negotiate rent with my landlord? The short answer is yes, but you're not going to get any movement on that. Because landlords don't have to. Leases are what we call contracts of adhesion. So all the power is on the side of the landlord. And if they have a property and they're renting it for $2,000 a month for their one-bedroom unit, and that's the going price, you can go in and ask them for sure. You can negotiate that, but they don't have to bring down the price. So, but you certainly can ask. There's no law that says they have to bring down the price. if they have a lot of empty units, maybe they'll want to, but they probably will not. So there is no cap on the amount of, moving on to the rent increases, there's no cap on the amount of a rent increase in Maryland. They can increase it as much as they want, as high as they want, but they must give notice. And the notice requirement in Maryland is 60 days if you're on a month-to-month lease, meaning if you had an annual lease and your annual lease stopped January 1st, your annual lease ended, and you didn't renew, or they didn't renew a 1-year lease. By operation of Maryland law, your lease continues on a month-to-month basis. So if you're on that month-to-month lease and it's under the same terms, okay, and that's just how it works under the law, under the same terms, month-to-month basis, but they must give you 60 days notice of a rent increase. That's allegedly, I guess, to give you the opportunity to move if you can't afford it. If it's an annual lease, then so your lease is expiring July 1st and they want to bump up your rent effective July 1st of this year, then they've got to give you 90 days before they can do that. If they don't do it, they're out of luck. So the notice is you must